blue one is at Lincoln.
Good morning. This webinar offers closed captioning. To enable closed captioning, click on the live transcript button on the bottom of your screen and choose your preferred method. Welcome to the Chicago Department of Business Affairs and Consumer Protection webinar. Please know any website or email that I mention will be posted in the chat box. For those seeking business licensing assistance, you can visit the Small Business Center at City Hall on the 8th floor or call 312-74-GO-BIZ. Also, business licenses can be applied for or renewed online at chicago.gov/business licensing. The BACP Entrepreneur Certificate Program now has a new portal. If you are already a part of the program, your account will automatically reflect the credit for joining this webinar within 24 hours. If you want to learn more about the program, please visit chicago.gov/BACP certificate. Also, this webinar is being recorded and will be available at youtube.com/ChicagoBACP. I will post the mentioned information in the chat box. We encourage attendees to ask questions. Please use the chat box to send your questions. There will be a Q&A session at the end of the presentation. Please note that the views, information, and opinions expressed during the webinar are solely those of the presenter and do not necessarily represent the official policy or position of the Department of Business Affairs and Consumer Protection or the City of Chicago. Today's webinar will be Entity Selection Formation, presented by the Donald Pritzker Entrepreneur Lawship Center, Northwestern Pritzker School of Law. Esther and Darren?
Hi, thank you so much for that introduction, and we're super excited to be here. I'm Esther Barron. I'm part of the Donald Pritzker Entrepreneurship Law Center at Northwestern Pritzker School of Law, a mouthful. And in our center, we have lots of classes focused on entrepreneurship and innovation, and we run a clinic where we represent clients, entrepreneurs around Chicago, and do things like workshops and office hours like we're doing with all of you today. And we really appreciate your being here. Darren, do you want to introduce yourself?
Sure. I'm not so different than Esther. I'm Darren Green. I'm also in the Donald Pritzker Entrepreneurship Law Center, teaching various and sundry classes around startups and entrepreneurship and venture capital and contracts and things of that nature. And we're really looking forward to being here today and talking about entities.
Okay, so we're going to get started. Just a reminder, if you have any questions, throw them in the chat. We'll definitely save time at the end to answer your questions, but if you want us to address them sooner, just put it in the chat and we're happy to pause and answer questions. So like Darren said, we're going to be talking about entity selection today. And so for entrepreneurs and business owners, a lot of times this is one of the first things to think about is setting up an entity so that you have an entity, a form to run your business out of. And so this may be review and things you already know, but I want to just start with like, what happens if you don't select an entity? Because there's some things that happen just by default, even if it's not what you actually intend. So if you are running a business and it's just you and you're selling something and you have customers, but you haven't filed any official documents with the Secretary of State, you are automatically what we call a general partnership. I'm sorry, a sole proprietorship. I was skipping ahead. You're a sole proprietorship. If you are running that same business, but you have a partner, anyone else that you're running the business with, even if you haven't made any kind of formal agreement or chosen any type of entity, you are by default, I gave it away already, a general partnership. So by default in Illinois, as with most other states, maybe all other states, when two or more people come together to run a business for profit, they are by default a general partnership. And so Darren and I and lots of lawyers don't really like sole proprietorships or general partnerships. And one main reason is that there's unlimited personal liability for the owner. So for the sole proprietor or for the general partners. And that means if you get sued or there's some liability, it's your personal liability rather than just the liability of the business, which, that's bad enough, but you don't want the personal liability. And so a lot of times I think it's easier to think about how this could come up with a real world example. So I'm going to share an example of something that I was involved in, not directly, but heard about. And this was a few years ago. A friend of mine, a former colleague from when I was in private practice, called me and said, Esther, I don't think this is a problem, right? And when someone starts with that, you know it's probably a problem, right? But she started with, Esther, I don't think this is a problem, but I want to run something by you. My cousin, who's a consultant, moved out west into a smaller city and was working for a consulting firm there and worked out at a gym. And so far, great. But while he was working out at the gym, he met this person who was a former athlete and kind of a pseudo celebrity in that smaller town. Everyone kind of knew who he was, he had some celebrity status. And he started working out with that former athlete as his trainer. Great, all good so far. So her cousin, who's the business person, says to the former athlete, pseudo celebrity, you know, I brag about that you're my trainer to people at work. Everyone thinks it's so cool. If you wanted more clients, I could so easily get you more clients. Like a lot of the people I work with would love to be trained by you. And the former athlete said, great. I could use the money. I have the time. If you have more referral, if you have people that would like to work out with me, please refer them. And so he referred a lot of his colleagues, and the trainer / former athlete / pseudo celebrity gave him, a certain percentage, maybe $10 or $15 every time he referred a client, maybe even more. Maybe it was based on how many sessions they had, but he was making pretty good money too. So they were both doing great. At some point, the athlete trainer said, you know what? Thank you so much. My schedule is full. Please don't refer anybody else to me. Like, I appreciate it. This has been great, but I actually don't have any more time. And the consultant said, well, that's too bad, because I still feel like there's a lot of people that would want to work out with you. And with, I kind of feel like we're leaving money on the table. And said, what if you created like a workout regimen? And I think people would still think it was great to be able to brag that they were kind of working out under your, the method that you designed, even if someone else was the actual trainer, if they were using the routine that you came up with. And I said, well, that would be pretty easy. Sure, I'll come up with like a design a workout and other people can be the trainer. And so they did this. They even set up a website, and people could put their, it was a very unsophisticated website, but you could put your email address in or your cell phone number. And so this went along for a while. They were both making, great money, very happy with it, until one day, and this is right before I got the call, they went out for breakfast or for coffee on a Saturday morning, and the trainer, former athlete, pseudo celebrity person said, I know you think of yourself as the business person, and I'm sort of the athlete implementing our business, but you're going to be really impressed because I have a surprise for you. I signed a lease on a whole new gym, and I ordered lots of gym equipment that's going to be delivered. I met with a bank to finance us, and I've done all of this sort of just so I could surprise you, but we're in it together. And here's some of the documents and the contracts I signed for hundreds of thousands of dollars worth of, like, if you combine the lease payments and the equipment he ordered. And he wasn't excited. My former colleague's cousin was not excited at all. In fact, he was horrified. And his first call was to his lawyer cousin to say, do I have any liability? Do I have any exposure? And this is when I get the call, Esther, I don't think this is a problem, but I want to confirm my cousin doesn't have any liability or exposure. And I hope you're all thinking back to what I said a few minutes ago about if you run a business, if 2 or more people come together to run a business for profit, they by default have set up or created what we call a general partnership. And in a general partnership, the partners have joint and several liability, which means that each partner is liable and responsible for the debts incurred by the other partner on behalf of the partnership. So unfortunately, I couldn't say to my former colleague, oh no, don't worry about it, this isn't his problem. What I had to say is, this sounds like maybe they inadvertently created a general partnership and there could be some significant liability for your cousin. We were able to work it out and sort of negotiate outs with the different third parties. He did have some significant exposure and lost some money, but it was an expensive lesson and he was able to move on. But for me, it's a great example of how you can inadvertently, a really smart person can inadvertently create a general partnership and expose themselves to a whole lot of unwanted and kind of like surprise liability and personal liability. So that kind of scary story is an example of why we form an entity. Darren's going to talk about some of the entity choices in a minute, but that's a bit of the why. We want to protect ourselves as owners from personal liability. Now, what I had said to my former colleague when we were having this conversation is, unfortunately, he likely set up a general partnership. If he had just set up a corporation or a limited liability, again, a limited liability company, again, those entities Darren's going to talk about, then it would have been only the business that had the exposure and not the individuals. And she said, great, that's really good news. Let's set up a corporation or an LLC so we can fix this. And I said, unfortunately, the problem is it's not retroactive, right? It's not looking backwards, it's only looking forward. So we could set up a corporation or an LLC, but any of the liability and all of the liability that was created before we set up the entity would still be personal liability. You can't fix what already happened. So the timing is really important. And there's no, magic time of when do you set up the entity. But the very general answer is, as soon as you're doing something that really could create liability or exposure for you individually, you want to create the entity to protect you from that liability. So, red flags would be, are you selling things? Are you offering your services? Are you taking on investors? Are you signing contracts? Those are some of the things that would point to, it's probably time to set up an entity. And again, the risk in delaying to set up the entity is that you have this unlimited personal liability exposure that you really can't fix looking backwards. You can fix for liability that happens in the future, but there's a moment in time where you set up the entity and anything that's happened before then, you have the personal liability for. So I just want to wrap up this the first part of our presentation on, it's important to think about setting up an entity early. And again, thinking about some of those red flags or indicators of when it might be the right time to set up an entity. And then making sure you thoughtfully choose which entity type is the right or best or most suited choice for your business and your particular situation. And with that, I'm going to pass it over to Darren, who's going to now talk about how you, what considerations you might want to think about when you're making that important decision. You've decided you want an entity, but which entity do you want?
Thank you, Esther. We're all going to try to avoid that scary story in our own lives. No one wants that to happen to them. So let's talk about how we can avoid that. So as Esther established, forming an entity early is generally a good idea for all the reasons she talked about. It can seem sort of daunting to founders and entrepreneurs, particularly entrepreneurs that are starting a business for the first time. It's this sort of unknown world. What does it mean to form an entity? Is it expensive? Do I need lawyers? That's one of the reasons that sometimes founders or entrepreneurs kind of put it off. They kick the can down the road. I'll sort of deal with it later. But as Esther suggested, earlier is better than later. So we're going to talk about a few things. Before we talk about which entity may be the right choice, I want to start with the process to form an entity, to sort of demystify it. It's not as scary as founders sometimes think it is. The process to form almost any entity that you would typically form is actually quite simple. Every state in the United States has a body of laws that allow you to form corporations or limited liability companies or limited partnerships, whatever type of entity you're going to form. The document you file with the state is very short. It's typically a page, maybe a page and a half. In most states, they ask for 4 or 5 pieces of information, and it's very basic information, the name of the entity, your address, things of that nature. It's usually not that expensive. Most states, it's $150, $175. So it's not nothing, but it's not thousands and thousands of dollars in order to form an entity. You submit this document. It's either called an Articles of Incorporation or a Certificate of Incorporation if it's a corporation you're forming. Maybe it's called Articles of Organization if it's an LLC. The name doesn't matter. It's just the document you file with the Secretary of State in the state in which you're going to form your entity. You file it. You file it with the state. You pay them a couple $100. You get a stamped copy back. You've got your entity. That's it. That's all you need to do. There's a few other things. You'll get a tax ID number, and there's a few other administrative steps. But forming the entity itself is very simple. There are documents that you might elect to sign if you've got co-founders, right, other owners of your business with you. You might sign things like shareholder agreements or founder agreements. They're called operating agreements in an LLC, and we're not going to go into those today. Those don't need to be filed with anybody. Those are just documents that you sign between and among the owners that you're going to keep in your files. So those are a good idea if you're going to have more than one owner, but you don't have to do them in order to form that entity and to get that liability protection that Esther was talking about. That process is simple. So if you are thinking of forming an entity and you haven't done it yet, you can get that initial filing done, get the liability protection in place. You'll open a bank account in the name of the entity, so you're operating sort of as an entity rather than as yourself, and you'll sort of get that initial liability protection. So that's kind of the formation part of it, which again is very basic. Another thing I want to talk about before we talk about which entity might be the right choice is the state in which you're going to form. I've mentioned a couple times you file to form an entity with the Secretary of State in the state in which you're going to form. All 50 states would love to have your entity. It's nice to have lots of businesses formed in a state. States make a little bit of money on it because there's filing fees when you form in a given state. So which state should you form in? There's no right answer or wrong answer to that question, but a couple of rules to sort of guide you. If you're in Illinois, your business is based in Illinois, this is where you're going to be running your business. Generally, Illinois is perfectly fine. Illinois has made it very easy to form entities. Many of the filings that you need to make to form an entity can be done online with the Secretary of State of Illinois. They've sort of updated their systems over the years. It's really quick and really easy in the state of Illinois. The Secretary of State also lowered their fees not too long ago, and nobody's complaining about that. You'll pay less to form an entity here than you would have a decade ago. So generally, if you're in Illinois, your business is here, Illinois works perfectly fine, and it's pretty cost effective to form in Illinois. But there are other possibilities that are worth at least mentioning. One possibility would be if your business is really going to be all over the place, lots of different states, or if you have co-owners of your business, co-founders that are located outside the state of Illinois, sometimes you start to say, well, we're not really focused in Illinois, we're kind of all over the place. You'll sometimes hear the state Delaware. Oddly, Delaware is not a particularly big state, but Delaware has lots and lots of entities that are formed there. The state of Delaware, many years ago, figured out that if they created a favorable body of law to protect folks that form businesses in the state of Delaware, that they'll get lots of formations there, lots of new entities, and they'll make lots of money. So Delaware for years has had lots and lots of new companies formed there. Particularly companies that are going to raise lots of money. So if you were going to, for your business, raise $5 million from venture capital investors, those types of investors typically prefer Delaware for their companies. But most companies don't raise $5 million, and most companies don't raise venture capital. So for most startup businesses, the fact that those types of investors prefer Delaware doesn't matter. If you're funding your business yourself, as most founders do, they call that bootstrapping, when you put your own money in your business to get it launched. You can do that in any state. You don't need to be in Delaware to bootstrap. And if you were going to raise a little bit of money from folks that you know, friends and family, we're going to put a little bit of money into your business to help get it going. Illinois works perfectly fine for that too. So I mentioned Delaware because you'll sometimes hear people talk a lot about Delaware as a state of formation. And if you're the kind of business that's going to raise all that money, or you're located all over the country, maybe Delaware would be worth thinking about. But most businesses, that doesn't sort of fit the description. And Illinois works just fine. You'll hear other states, Nevada's been marketing themselves, Alaska's been marketing itself. All these states want businesses to form there. But again, if you're in Illinois, probably not all that much reason to go out to Nevada or Alaska unless you had some sort of unique circumstances. So we've talked about the process to form, very easy, a filing that you can get on the website of most Secretary of States that you can submit with the Secretary of State in your state of choice. We've talked about the choice of state, probably Illinois for most businesses that are here, maybe Delaware for the outlying businesses. And now we get to the sort of the biggest question, and it's one of the trickiest questions for founders. So they know they need to form an entity for the reasons Esther mentioned. They know the basics of how to do it, but what should they form? And that's a good question. So there's lots and lots of choices. We know we don't want to be a general partnership. As Esther mentioned, that's kind of a bad word or a bad couple of words. We get none of liability protection we're looking for in an entity. There's a form called a limited partnership, which I'm going to mention mostly to suggest we're not going to talk about it much. The reason is limited partnerships have become much less popular over the years. Very, very few startup companies or early stage businesses form as limited partnerships because there's better options typically for most founders and business owners. There's a couple of types of businesses where you'll still see limited partnerships floating around out there, but it's an unusual choice for a startup company. So I mention it so you know that it exists. But we're going to move on because in all likelihood, you're not going to choose that form of entity. So let's start with corporations. Corporations, everybody's heard of. It's an old form of entity. It goes way back. Corporations have been around for a long time, and it's a very popular choice of entity. The basic corporation, the standard corporation that you form with, in Illinois, it would be called an Articles of Incorporation. That's the document you'd file with the Secretary of State. That type of corporation, when you form it, is what's called a C corporation. Why C? Why not? That's what they call it. It's a C corporation. That's the basic fallback corporation when you form. So what are some of the benefits of a C corporation? One of the principal benefits is you get that liability protection that Esther was talking about. Once you form a C corporation, you're no longer at risk. You shouldn't be at risk of personal liability should things go wrong, as they always do with most startup companies. Things happen. And if there's going to be a lawsuit, if someone's going to sue, that corporation, that C corporation, should absorb the lawsuit. They can file against the C corporation, but you as an owner, as a shareholder of that corporation, they shouldn't be able to go after you personally. So we get off that liability concern that Esther talked about. C corporations are very good at that, providing that shield around all the shareholders and owners so that they're not risking their personal assets should something go wrong or should there be a claim against the business. So that's one benefit we get from a C corporation. C corporations are fairly flexible. Anybody can be an owner, meaning other individuals can own shares in a C corporation. If you wanted to give out equity to folks who are going to sort of be working for the business, you can raise money from both a person can invest in your C corporation, an entity can invest in your C corporation, like a fund or anybody else. So there's no restrictions on the types of shareholders you have. They can be located anywhere. They can be in the United States. They can be in other countries, perfectly fine with a C corporation. If you wanted to get really complicated and issue different types of equity, if you're going to raise money and take in investors, sometimes investors like a different type of stock than the founders get. They call that preferred stock. You can issue that preferred stock out of a C corporation. So all of these things are positives, all benefits to a C corporation. It's why it's been a popular choice over the years. So you might wonder, why not always form C corporations? Why talk about any other form of entity? C corporations sound pretty good. And they are pretty good in many circumstances, but they're not perfect. There are a few issues with C corporations, and one in particular, which I'm going to mention. It involves taxes. We get very scared when we start to talk about taxes. Nobody likes to talk about taxes, but we have to a little bit when we're thinking about forming an entity because they're relevant. Some of the decision-making that we make in deciding what type of entity to be, unfortunately, are tied to the taxes that we're going to pay based on that choice. You may have heard the term double taxation, or maybe you haven't heard the term double taxation. It's a term you sometimes hear with C corporations, with basic corporations. And the way it basically works is as follows. When a C corporation, if you're operating your business out of a C corporation, and you make money, the IRS treats that C corporation just like a person, just like you pay your taxes every year, your C corporation pays taxes every year. And so if you're profitable, let's say you make $10,000 for the year, the end of the year, that C corporation, just like a person, pays taxes to the IRS and pays state taxes to the state of Illinois or whatever other relevant state may come into play. So that's all fine. But let's say that C corporation is sitting on those profits, it pays its taxes, and that C corporation also wants to give a little money back to its shareholders, right? It doesn't need that money for the coming year, and the shareholders kind of want that money back out of the C corporation. We call those dividends. You've probably heard the term dividend before. It's just when a corporation gives money back to its owners, to its shareholders. The dividend is also taxable. The IRS looks at that distribution of money and it taxes that dividend as well. So that's a second tax. When you think about a corporation, it pays taxes on its profits. And then if it declares a dividend to its shareholders, they pay tax on those dividends. That same dollar that the corporation earned has been taxed twice. That's why they call it double taxation. So we generally don't like to be taxed more than once. I don't know much about taxes, but one tax is better than two taxes. So that's not a very efficient way to make money. So that's one of the big drawbacks of a C corporation. How do we deal with that? Well, there's a different type of corporation called an S corporation. An S corporation is exactly the same as a C corporation. It starts out like a C corporation, but you make a separate filing with the IRS. And when you make that filing, you're asking to be treated as an S corporation. You're making what's called an S election. So let's talk about S corporations because we do see them out there. With an S corporation, you get the same liability protection we talked about with a C corporation. You're sort of building that shield around yourselves, meaning if somebody's upset with your business and they sue, they should be limited to suing the S corporation and not the shareholders personally. So S corporations work well for that. But S corporations solve one of the issues that I mentioned for a C corporation, that double taxation. In an S corporation, profits that are earned by the S corporation are only taxed one time rather than twice. S corporations are what we call disregarded entities. And by that we mean the IRS disregards them. It pretends they don't exist in many ways. The IRS, for the most part, there's all sorts of quirky rules when we get into taxes, but for the most part, the IRS will not tax that S corporation on its profits. The IRS will instead just tax the shareholders, one tax on those profits. The profits they flow through the entity. You'll sometimes hear S corporations referred to as a flow-through entity, and that's what they mean. The profits are deemed to flow through. The IRS ignores that S corporation and taxes just the owners. One tax versus two. So that's great. That solves that pesky tax problem that we ran up against with a C corporation. So you may be wondering, why don't all startup companies and early stage businesses form as S corporations? You get the liability protection. We get one tax versus double taxation. That seems perfect. The reason is S corporations have a whole set of rules that come along with them, rules that we don't have in C corporations. For example, in an S corporation, there's a limit on the number of shareholders you can have and still be an S corporation. Now, it's a big number. It's 100. So for most startup businesses, that particular rule isn't a problem. It's rare for a company to have more than 100 shareholders, but they've got other rules. For example, you can't issue more than one class of stock. I mentioned in a C corporation, if you're going to raise money from investors, they're going to want a different type of stock than you, the founders, have. In an S corporation, I can't do that. All I can issue is that one class of stock, that common stock. So I can't really raise money for the most part. From lots of types of investors, I won't be able to raise money in an S corporation. There's even more rules. I can't have shareholders that are not sort of US nationals. If I want to have a shareholder, let's say I'm going to co-found my business with somebody who's based in Mexico. That's where they live. Can't do it in S corporation. Have to be US nationals. I mentioned in a C corporation, I can have owners, shareholders, who are both individuals and other entities. Can't do that in an S corporation. All of the owners need to be individuals. They can't be entities. So this new set of rules turns what would otherwise be a really good choice, the S corporation, into a tricky one. So what do? The C corporation is great, but we've got these potential tax issues. S corporation solves the tax issues, but it imposes all of these rules on us, and maybe we can't live with some of those rules. Where do we go from there? And where lots of founders go is to the third popular choice of entity. And that's the limited liability company, or LLC for short. You'll often hear the term LLC. It just means limited liability company. The LLC was invented 50 or so years ago out west. I believe it was Wyoming, of all places. And it was kind of taking the best of both worlds. Basically, the LLC, we said, look, we're going to take the best of a C corporation, and we're going to marry it with the best of an S corporation, and we're going to get rid of all of those annoying rules that the S corporation imposes on us, and that'll be the LLC. Limited liability companies are formed the same way we form a corporation. There's a filing with the Secretary of State that I talked about. The filing is called something different, but it's the same basic. It looks very similar to articles of incorporation. So it's easy to form. We get the liability protection with an LLC. So that shield of liability that we put around ourselves that we get with the C corporation and an S corporation, we also get with an LLC. So that's a good thing. That takes care of issue one. LLCs, as it relates to taxation, they're taxed much like an S corporation, meaning one tax versus the double taxation we saw in a C corporation. So it solves that problem too. We get the liability protection. We get one layer of tax. It's a flow-through entity, just like an S corporation, versus two layers of tax. But importantly, most importantly, we have none of the rules that we had in an S corporation. Meaning, we can have any number of owners. They're called members in an LLC. Same thing as a shareholder in a corporation. They're just called something different. So we can have any number of members. They can be located anywhere in the world. They can be entities or they can be individuals. I can issue different classes of equity if I want to bring in investors that want some sort of special preferred class. So it's like the best of both worlds. LLCs are also, you'll often hear them referred to as a flexible entity. They're very flexible. We won't go too deeply into the rules you have to follow when you to sort of be a C corporation versus being an LLC. But in corporation structures generally, in order to stay a corporation and to keep that liability shield around yourselves, there's often rules imposed by state law. You have to hold board of director meetings and you have to hold shareholder meetings. And if you don't do these things, you might end up being liable rather than the corporation. LLCs, those requirements around holding meetings for members and holding meetings for the board, there's less of them. You don't have to do those things to the same extent you do within a corporation. You can sort of operate the way you want to operate in an LLC. So there's less risk of kind of messing it up and having that liability shield drop because we messed it up. So LLCs, for all the reasons we just talked about, have become a very, very popular choice for startup companies. Some tax efficiencies, liability protection, and none of the rules of an S corporation. It is worth mentioning a few drawbacks, potential drawbacks of an LLC. One of them is the accounting in terms of filing your taxes each year. It can get a little tricky. There are these things called capital accounts that are formed within LLCs. There's documents called K-1s, which are issued to the owners of LLCs at the end of each year so they can file their taxes. It's not important to know what those things mean. It's just sort of important to know that they exist. And they're, for most founders, they're a little complicated. Unless you're an accountant, you wouldn't necessarily know how to do them. So when you form an LLC, we definitely want to have an accountant that has dealt with LLCs before. If you have an accountant that knows how to deal with LLCs, these things are easy. They can handle it easily. But if you're someone who likes to do your own taxes for your entity, when you have an LLC, they can get a little bit more complex. So it's just something to bear in mind. The other thing to bear in mind is if you're one of those companies, they're rare companies that are going to raise lots of money, millions of dollars. If you're that kind of business, you're going for really rapid growth and you're going to get these professional institutional investors involved. Those types of investors, often for a variety of reasons, and we won't go into all of those reasons here, but for a variety of reasons, they prefer C corporations rather than LLCs or S corporations. They don't like that single layer of taxation, oddly, and it has to do with the way those investors are structured. So again, most companies aren't going to raise millions of dollars from venture capital investors, but if you happen to be one of those, then you think about being a C corporation. So those are the most popular choices: C corporation, S corporation, and limited liability company. What you choose will largely be based on your personal circumstances. How you're going to fund the business, where you're going to be based, and all of those things. One important thing to note, we often get the question, am I stuck? So if I pick an entity form, and I go with that, and I form my entity, and I file with the Secretary of State, and I create all the documents that I need, and then I decide 6 months later, I either A, made a mistake, I should have been a different form of entity, or my circumstances change. It was the right choice for the time, but now, given where I am, I think I should be a different type of entity. You know, am I locked into that first choice? And the answer is no, you're not locked in. It used to be sort of a headache to go from one structure to another. There was, you almost had to do like a little mini transaction with lots of documents in order to sort of switch your form of entity or switch states. You know, if I start in Illinois and I need to go to Delaware, or I started in Delaware and I want to become an Illinois entity, it used to be difficult. Now there's a process called statutory conversion, which is just a complicated way of saying going from one entity type to another. So if let's say I'm an Illinois LLC and I decide I need to be an Illinois C corporation, there's a filing I make with the Secretary of State of Illinois called a statutory conversion filing. It's a page or two. It's not that complicated. And by making that filing, snap your fingers, you instantly become the type of entity you want to become. You're not even really a new entity. You keep the same employer identification number, which is the number the IRS issues to every new business. It's very simple. If I want to leave the state, let's say I start as an Illinois LLC, and I decide I want to become a Delaware C corporation. I can do a statutory conversion from the state of Illinois into the state of Delaware and switch forms of entity as I move across the country. So you're not locked into your choice. Most businesses, when they form their initial entity and they make that choice, they stay that entity. That entity is usually perfectly fine for them. But should you be one of those entities that decides you need to make the change, there's simple, not expensive filings you can make with the Secretary of States, the relevant Secretary of States, in order to move from one form or one state to another. So that's sort of it in a nutshell. And I know we've gone through that very quickly. There are full semester classes on all of these topics. It would be sort of boring to go into that level of detail here. We want to keep you alert and awake. So with that, I know I see some questions already in Q&A, and I'm guessing there's probably some other questions. And we always like to make sure that we address what it is that you want to know. So if you've got questions, you can post them in the chat, or you can post them in Q&A, however you'd like to.
I think the chat seems to be disabled. So let's do Q&A. And why don't I take the first question? I know, Lisa, you asked a question a while ago. So apologize for taking a little bit of time to get to it, but here we are. And your question is that you have a few different businesses and you want some guidance about creating a holding company with subsidiaries, or would it be better just to have one company with several DBAs? And there's chat should be working now, so you have your choice. So it depends on your reasons for why you would be thinking about a structure with a holding company and subsidiaries. And for those of you who don't necessarily know what that structure means, a holding company would be the parent company, and it would own several companies underneath it. So that would be a more complicated structure. And sometimes that structure makes sense. One reason would be if the different businesses have significantly different liability risks, and you want to separate that liability from vis-a-vis the other company. So that would be one reason you want to separate liability. Another reason would be if they have different investors, so a different ownership structure. Maybe you would have, although with a holding company, it would all be owned by the holding company, but you could have other investors. Most of the time for our clients, what makes more sense, and maybe is what you're getting at, is you'd have one company, and within that company, you might have different divisions, and you could use different, my clients don't typically do DBAs as much as they have different brands. And so one company could have several different brands. And an easy example of this, if you think of Procter & Gamble, so that's one big company called Procter & Gamble, and then they have many different brands or different divisions. So if you think about like Old Spice as a deodorant, or a cologne, Secret deodorant, Tide laundry detergent, Crest toothpaste. These are not all separate companies, but they're all part of Procter & Gamble, and Procter & Gamble has registered trademarks. We're not going to talk about trademarks, but they have trademarks so that they can have all of these separate brands. So if there's not like a real reason to have separate companies, which makes it much more complicated from a tax perspective, from a filing perspective, from a tax return perspective. A lot of times it's more efficient to have one company with different divisions, or several different brands within the company. Hopefully that answered your question.
I will take the next question. There's lots of good questions here. Keep them coming. Again, we love the questions. So I see a question here. When forming an LLC, do you do so as a sole proprietor? And that's a good question. Sometimes when there's a founder operating a business by themselves. So let's say you're a founder and you don't have other owners of your business. You don't have co-founders. It's just you. The thought is, well, do I need to do anything? Can I just be, and Esther mentioned sole proprietor. You could just operate as yourself. But the answer is yes, you still can form an entity. And in fact, it's a good idea generally to do so. You'll see a lot of single owner businesses. Let's say you have a consulting business and you're just providing help and advice to other folks or other companies, and it's just you. You could form an LLC, right? And you're the only owner of that LLC. It's called a single member LLC, which is just a fancy way of saying a single owner LLC. you would still be putting that liability shield around yourself, right? You'd be operating as an LLC. The LLC would open a bank account in the LLC's name, so it wouldn't be your personal bank account. And it feels a little strange because it's just you. And so it feels like, well, wait a minute, it's just me regardless, but it's actually not just you. If you form an entity, there's just you, the person, and then there's the LLC that's deemed to be a separate legal person entirely. And if something should go wrong, and as we talked about, things often do go wrong, the problem will stop with the LLC. Any lawsuit or disputes, you'll sort of limit them to the LLC, and you, the person, will still be protected from those things. You shouldn't be party to those things. So the answer is yes. Even if you're an individual, you're not raising money, you're not going to have co-founders, you can form any of the entities that we talked about to put that liability shield up sort of in front of you and make sure that you're sort of protected, even if it feels a little unusual to be doing it. And I'll give Esther the next one.
So I'm going to take the not-for-profit question. So Deborah, you asked about what about not-for-profits? What are the pros and cons of 501c3? So I'll talk a little bit about that. We didn't talk about not-for-profit corporations, but of course that's an option too. That's an entity you can set up instead of a C corporation or an S corporation or an LLC. You can file articles of incorporation with the Secretary of State and create a not-for-profit corporation. The not-for-profit corporation can then apply with the IRS for tax-exempt status, the 501c3, and they do that by filling out a 1023 form with the IRS. There are two different application forms. There's a very simple one if you're not going to be raising a ton of money, and a more complicated one if you are going to be raising more money. And so the not-for-profit corporation doesn't automatically have that 501c3 status. And so you want to separate a lot of times people use those terms interchangeably, but the not-for-profit corporation is a state law concept. It's a state entity. And then that entity has to apply to the IRS for tax exempt status or 501c3 status. And then the benefit is, like it sounds, you don't have to pay federal tax. You're exempt from paying federal tax. So, and also if you get donations, there's benefits for the individuals who are making donations to the entity. But we don't have time to get into all of this, but there are a lot of guidelines and sort of tests or standards that you have to meet in order to qualify to be a not-for-profit corporation and to get that tax exempt status from the IRS. The last thing I'll say is you want to be really sure that that's what you want to do. So with a not-for-profit corporation, Darren talked about who owns entities. Like a C corporation, the shareholders own the entity, right? They own stock in the corporation. With an LLC, the members own units in the LLC. With a not-for-profit corporation, there are no shareholders. The public is really the beneficiary of the owner of the not-for-profit corporation. So you can't sell it. Like if it becomes really big, that's great. If your goal is more of a social enterprise or mission-based entity, terrific, but you can't sell it. You can have a salary, but that's really the only way. And unlike the other entities that Darren talked about, where it can be pretty easy to convert, not with a not-for-profit corporation. You can't convert then to a for-profit corporation. It's pretty complicated even to get assets out. So again, you want to be pretty sure very sure that that's the route you want to go if you go to the not-for-profit corporation route. I'll mention one last thing, and then we'll get to the next question. There's also kind of a hybrid entity or a middle ground, which is called the public benefit corporation, which is a for-profit entity that could have a social or does have a social mission. So there's that option, which is a newer option, not available in every state, but is a newer option that entrepreneurs that are more social entrepreneur mission-based can at least consider.
All right. I see a question here. What do I need to know about after getting my LLC? And I see a reference to sort of an EIN, and that's a good question. We've mentioned a few of these things, but when you think about the process to sort of launching your entity, kind of what do you need to do? Forming it is the first part, and that's what we talked about. So once you form the LLC, let's say you form an Illinois LLC, The next thing you'll often do is get that EIN. I mentioned employer identification number. You can do that at the IRS website. It takes 10 or 15 minutes. It doesn't cost anything. The IRS will ask you some questions, and you answer them, and then you download a letter which has your EIN on it. And often the next thing founders will do, so they've got their entity formed with the Secretary of State. They've got their EIN from the IRS, lots of letters there. And then often you'll go open a bank account. So you'll go to your local bank or whatever bank you work with. You'll take the document you filed with the Secretary of State. You'll take that letter from the IRS, which has your EIN, and you'll open a bank account in the name of the entity so that you're operating only out of that bank account. You're not using any of your personal money. We don't want to, there's a sort of a bad word called commingling. You want to stay away from commingling. The business is the business and your personal life is your personal life. Once you've done that, you're generally up and running. There are a few other filings that you'll also want to think about. For example, in the state of Illinois, you would register your entity with the Illinois Department of Revenue. There's a separate filing that you make to register for taxes at the state level. And that's a filing that startups will often work with their accountant on. It's a little more complicated than some of the other filings, but you got to register with the Illinois Department of Revenue. And then depending on where your business is, located, for example, say if you're in the city of Chicago, the city of Chicago offers city of Chicago business licenses. You can get them fairly easily. Again, you can go online to get the application for the city of Chicago business license. And so if that's where you're based, you'd want to get that license as well. If you're located not in the city of Chicago, if you were somewhere else, wherever you are, may have their own local license that you would get to do business in that location. So those are some of the other licenses you'd think about, the Illinois Department of Revenue, City of Chicago business license. None of these things take all that long. If you devoted a half a day to all of this, you probably will get through most of it. And once it's done, the good news is it's done. You're registered, you've got your numbers, liability protection, and you're off and running. Esther, you're up next.
I'm up. So I'm going to answer the question. Someone asked about the L3C and what would be the benefits of that. And that's kind of another hybrid entity. This is originally, so I have to give you a little bit of background. When foundations make grants to not-for-profits, that they have to use their money to make grants to not-for-profits. Foundations can also do what we call program-related investments. So it's not a grant, but it's an investment. And the hope was that you don't have to get a private letter ruling from the IRS if the PR, which you have to do. Foundations have to get a private letter ruling from the IRS that the program-related investment is okay into it in an entity, a for-profit entity. The hope was that the IRS would give like a blanket grant for L3Cs to say, yes, if you do a PRI in L3C, it's okay. They never did that. So actually L3Cs, from my knowledge and my experience, aren't used that often. It seems to me, again, anecdotally with my clients and in my practice, that if you have a social entrepreneur, someone who wants to have a for-profit business, but also has a social mission that's really important and they want to tie it to the type of entity, I'm seeing more entrepreneurs choose the public benefit corporation or the B Corp over the L3C. Again, that's my experience. I don't know if that is reflective of trends at large, but that's certainly what I see.
So I'm going to take two questions that are sort of related to each other. They're kind of liability related questions. I see one question about, so I can have one LLC with different divisions, rentals, realtor, entertainment. And I see another question asking about if you're a sub S or an LLC and you're requested to sign a personal guarantee, should you do it? And again, these are both sort of liability. My answer is going to be liability answers. The question around the divisions, you absolutely can do it. As Esther mentioned, you can have one entity with lots of different divisions in it. You'd want to think about if they were very different businesses in the same entity, and you felt that one business created a big liability risk. There was a big chance you were going to get sued because it was a high-risk business. And the other business you were operating out of the same entity was a low-risk business and making lots of money. You might want to do those out of two separate entities because if you do get sued, you'd rather have the high-risk business. You'd rather that be the only one that gets sued should there be litigation. And you could keep your low-risk business separate in a different entity so those assets are protected. It's more complicated, as Esther mentioned. Having two entities is more complicated than one. It's a little more expensive. So lots of times startups will consolidate all their businesses in one, but it's worth being aware that if there's a liability risk for one of those divisions, separate entities may become worthwhile so that you don't risk all of the assets of all of your businesses within the same entity. Similar to the question about signing personal guarantees, that's also a liability question. The answer is a tricky one there. In a perfect world, you'd rather not sign any personal guarantees, right? Because if you form an entity and you sign a personal guarantee with somebody, you've sort of done away with one of the main benefits you got from the entity. You're no longer shielded from at least that liability that's described in that personal guarantee. For example, if the entity borrows money and you sign a personal guarantee as the shareholder to repay that loan, you're personally liable. So while we would rather avoid personal guarantees, we can't always do so. I mentioned a loan. If you're looking to take out certain types of loans, certain SBA loans or whatever the type of loan it might be, there may be a personal guarantee requirement in order to get the loan for the business. And if you need that money to grow your business, and that's the best way to get it, sometimes founders will sign personal guarantees. You just want to do it with your eyes open, though. You want to recognize what you're doing and recognize that if things go wrong and the company can't pay it back, that you're going to have to pay it back individually. It's not necessarily the wrong choice. You're just increasing your risk. And as long as it makes sense to take that risk on, then we do it.
Okay, so I'm going to take the question about you're in Illinois, but you set up a Delaware entity. And Darren mentioned some of this already, but I think it bears repeating. So you're located in Illinois, but you're setting up a Delaware entity. There's a couple things that you actually have to do. And again, Darren mentioned this in his presentation, but you have to file with the Illinois Secretary of State to be a foreign entity doing business in Illinois. So you're in Illinois, your inventory is in Illinois, but you're a Delaware entity. So you have to file a form and qualify to do business as a foreign entity in Illinois because Delaware is considered a foreign entity in Illinois. The other thing that you have to do is you have to hire a registered agent. So if you're in Illinois and you're an Illinois entity, you can serve as your own registered agent if you live in Illinois. And a registered agent is just someone really who accepts service of process. If you get sued or any official notices from the Secretary of State, if you form in Delaware, you have to hire a company to serve as your registered agent, and that's a couple $100. So there are some, minor complicating factors, but depending on your situation, those may be worth it. But again, there's additional expenses that come up if you are in Illinois, doing your business in Illinois, have your inventory and your employees in Illinois, but you set up as a Delaware entity. There are a couple extra steps that you need to take.
And I think, I think we're pretty much at time. Why don't I take one more? I see one that's been here for a while, so I did want to get to it. And then we can wrap up. There's great questions here. These are fantastic. Are there different rules for forming an entity for a licensed professional, such as a doctor or a lawyer? And again, we're not going to go too deep into the details here. The answer is potentially yes. There are certain regulated industries, and you've identified a couple of them. You'll often see the term professional corporation or things of that nature. So it's often a very similar process to form one of these professional corporations. You look in the state in which you're forming and see what the rules are in that state. What does the document you file look like? Often it's very similar to what you file when you're forming a non-regulated type entity. So the answer is yes, it may be a little bit different. It'll be similar. In many ways, it'll be similar to how you'd form another entity, but there may be different, slightly different information that the state is asking for. There may be slightly different requirements to maintain that entity, what you have to share from year to year. So yes, it can be different for licensed professionals. And I think with that, we're going to have to wrap up, unfortunately, but this has been fantastic. We've enjoyed sharing these very quick thoughts with all of you. We always love doing this, and we wish you all the best with all of your businesses and startups and everything else.
And keep in mind, if you do want more legal help, at the beginning of each semester, we take clients. And so we will, I think, share our application that can be forwarded to you if you're interested. And with that, we will say goodbye and thank you so much for being with us this morning.
Great. Thank you so much, Esther and Darren. As always, such a great presentation. Thank you. Thank you. This is so helpful. All the stuff's coming through the chat right now, but really, thank you very much for such great information. Hoping everyone has a safe and fun weekend. Thank you, everyone. Have a great day.
Right.